Welcome to this explainer. Today, we're going to dive right in and meticulously unpack the attached presentation on Module 8. This covers the deeply fascinating world of trial and judgment. Our main goal here is to make sure every single concept and procedure outlined in these materials is crystal clear for you. We're going to demystify these complex, multi-layered criminal trial procedures, taking you on a chronological journey right through the beating heart of the legal system. Let's get to it.
Here's our roadmap. We've got 5 main stops: types of criminal trials, the anatomy of a trial, rights of the accused, court powers and witnesses, and finally, judgments and digital justice. All right, Section 1, types of criminal trials. Let's set the ground rules.
Before we walk through a trial day by day, we absolutely have to understand the playing field, The system meticulously categorizes offenses. It's really all about the severity. So, a minor hurt might be handled in a fast, summary-like summons trial. But on the flip side, serious crimes like murder demand a lengthy, highly structured sessions trial. Basically, the sheer severity of the crime entirely dictates how formal the proceedings are going to be.
Now, there's a super interesting distinction when we look at warrant trials, and it all depends on how they actually start. Notice this crucial difference. If a case kicks off based on a police report, like an FIR, the magistrate simply checks the documents and frames a charge within 60 days. Boom! But if a case starts from a private complaint, sections 267 to 269 kick in. This means the magistrate actually requires initial prosecution evidence before they can formally frame the charge against the accused. It's a completely different workflow.
Moving right along to Section 2, Anatomy of a Trial. This is the chronological journey.
Let's look at how a standard trial actually builds momentum from the very first day the accused steps foot in court. Following sections 252 through 258 for sessions trials, every major trial basically hits 4 sequential steps. First up, framing the charge. The judge asks, "Do you plead guilty?" If they claim a trial, we move to step 2, prosecution evidence, where witnesses take the stand. Then, assuming there's no immediate acquittal, we hit step 3. The defense brings their evidence. And finally, step 4 brings us to the arguments, where both sides get to sum up their entire case.
Okay, so the truly crucial part is what happens the second those arguments wrap up. Under Section 258, the judge delivers a judgment, either acquittal or conviction. But here's the catch. If it's a conviction, the trial doesn't just instantly end with a punishment. No way. The judge actually has to hit pause and specifically hear from the accused regarding the severity of the sentence before passing that final sentence according to the law.
Which brings us to Section 3, Rights of the Accused. Let's talk about constitutional protections.
You see, a trial isn't just a rigid checklist of court procedures. It's heavily balanced by some profound constitutional rights designed to protect the accused from the overwhelming power of the state. A foundational protection you definitely need to take away from this explainer is the concept of double jeopardy, governed by Section 337. In plain English, it means a person who has already been convicted or acquitted simply cannot be dragged back into court and tried again for the exact same offense or on the exact same facts.
This principle is so incredibly vital that it's not just some standard procedural rule. It is literally enshrined directly in Article 20, Clause 2 of the Indian Constitution. But pay close attention to the specific wording here: prosecuted and punished. For this absolute constitutional bar to kick in, there must have been both a previous judicial prosecution and a punishment. That "and" is a very important detail.
So, that begs a really fascinating question. What happens if a trial is cruising along and the court simply forgets to ask the accused about a highly specific piece of evidence that's being used against them? Can a conviction legally stand in that scenario? Let's find out. That exact puzzle brings us to the landmark case of Narsingh v. State of Haryana. In this specific case, the accused was convicted, but the trial court had totally failed to put certain incriminating facts to them during their examination under what is now Section 351. And guess what? The higher court completely threw out the conviction. They ruled that you absolutely cannot use evidence against someone if they were never given a fair chance to explain it. It comes down to a mandatory requirement of natural justice, audial alterum partem. You simply have to hear the other side. And beautifully complementing that right to a fair hearing is the absolute right to remain silent, which is detailed in Section 353. An accused person can act as a witness for their own defense on oath, sure, but only if they specifically request it in writing. If they choose to just sit there and not testify, the court is strictly forbidden from drawing any adverse inference or making negative comments about their silence. Their silence cannot be weaponized against them.
Moving to Section 4, Court Powers and Witnesses. This is all about controlling the courtroom.
Now, while the accused clearly has robust rights, the court simultaneously wields some immense, dynamic powers to make sure the wheels of justice don't just, well, stall out completely. To prevent those agonizing, endless delays that legal systems are so often criticized for, Section 346 steps in to mandate that trials proceed on a day-to-day basis. In fact, the law strictly limits the court to a maximum of just 2 adjournments. And no, a lawyer simply being busy elsewhere is absolutely not a valid excuse for a delay. Here's another twist. What if a surprise suspect is suddenly discovered halfway through witness testimony? Well, the Hardeep Singh case confirms an extraordinary power under Section 358. If evidence suddenly emerges mid-trial that an uncharged person is actually involved, the court can literally yank them right into the proceedings. Now, this does require strong evidence, meaning something way more solid than just a prima facie case, but it's a crucial mechanism to ensure real offenders don't just slip away because the initial police investigation happened to miss them. That being said, there is a hard limit to this power, and that was clarified in the Sukhpal Singh Kaira case. The court drew a very strict boundary here. Yes, you can summon an additional accused under Section 358 anytime before the judgment is pronounced, but the second the trial ends and the judge gives that final verdict, they become functus officio. That extraordinary power vanishes into thin air.
But wait, what if a suspect tries to derail the whole system by just running away? Well, Section 356 has an answer for that. If an accused absconds, the trial can actually forge ahead in their absence. The court has to issue 2 warrants and publish a notice in the newspaper first. And to keep things fair, legal aid is provided to represent the person who fled. The kicker? The evidence recorded during this time can absolutely be used against them when they are finally caught.
And to further protect the integrity of the courtroom, especially the brave folks stepping up to testify, Section 398 places a mandatory, non-negotiable duty on state governments. They actively have to prepare and notify a witness protection scheme. This is vital to shield vulnerable witnesses from threats, coercion, or intimidation, and it directly strengthens the entire justice delivery system.
All right, our final section. Section 5, Judgments and Digital Justice. The final verdict.
As we finally reach the conclusion of our trial timeline, we see that incredibly strict rules govern exactly how, when, and in what format that final gavel falls. Under Section 392, a judge can't just sit on a decision forever. Once arguments wrap up on day 0, the judgment absolutely must be delivered in open court within a maximum of 45 days. And because transparency is key today, a digital copy of that judgment has to be uploaded within a strict 7-day window right after it's delivered.
Now, when the stakes are at their absolute highest, meaning a death sentence, the procedure is intensely scrutinized. According to Section 407, if a sessions court awards a death sentence, it cannot be carried out immediately. No way. The accused is committed to jail, and the case is mandatorily sent up to the High Court for confirmation. Under Section 409, the High Court acts as a vital safety net here. They can confirm the sentence, annul the conviction entirely, or even order a full retrial.
But honestly, perhaps the most fascinating modern evolution we see in these source materials is Section 530. This rule literally pushes the entire legal apparatus into the future. It explicitly allows for trials and proceedings to be held in electronic mode. We're talking digital summons, witness evidence captured via audio-video links, and even appellate proceedings happening totally virtually. It is a massive leap for accessibility.